Hello, I'm Chris Burns. I'm a partner and head of the family team here at Lupton Fawcett. Today I'm going to talk to you about prenuptial agreements and where the law currently stands in relation to those agreements. I thought it'd be helpful to run through some of the typical questions we get asked by clients when they come to instruct us and talk to us about entering into a prenuptial agreement. The legal status of prenuptial agreements is developing, so please keep an eye on those developments and you'll find those on our website. One of the key questions we're asked by clients initially is what's the legal status of prenuptial agreements at the moment? Well, at the moment, such agreements are not legally binding. Agreements cannot override a court's ultimate discretion as to how assets should be dealt with upon divorce. Currently, the courts are likely to uphold a prenuptial agreement as long as it's entered into fairly by both parties and both parties have a clear understanding of what's involved and its implications. It's only if such an agreement is manifestly unfair to one party that a court would be unlikely to uphold the terms of such an agreement. Many clients ask us whether these agreements can stop their other spouse from making an application to the court for financial remedies. Prenuptial agreements cannot stop a spouse from making such an application to the court, and any attempt to do so or any waiver of the right to apply to the court for financial relief within divorce will not be effective if it's part of the prenuptial agreement. So does the agreement have to be entered into freely by both parties? Well, absolutely. That's a fundamental requirement of these agreements. There must be no pressure applied from one party to the other, or indeed from any third party to either party of the agreement. If there's any kind of undue influence or mistake or undue pressure applied from one party to the other, or if one party attempts to exploit a dominant position insofar as the other party is concerned, again, the court will not uphold such an agreement. It's a fundamental requirement that both parties must enter into the agreement of their own free will. Both must be free of pressure from the other party or indeed any third party. Courts are not likely to uphold agreements if there's any kind of duress or undue pressure applied on either signatory to the prenuptial agreement. Equally, if one party attempts to exploit a dominant position in relation to the other party to the prenuptial agreement, the courts would be very slow to uphold the terms of such an agreement. Both parties should be on an equal footing and freely able to negotiate the terms of the prenuptial agreement with each other. So what are the key factors of a prenuptial agreement that is likely to be binding? Importantly, the terms of the agreement have to be negotiated well in advance of any wedding date. Both parties will need to have sufficient time to consider the terms of the agreement and to take their own independent legal advice. Courts will also take into account individuals' circumstances, such as each party's emotional state at the time of entering into the agreement. Courts will look at the age and maturity of both signatories to the agreement, and if one party is more mature than the other or has life experiences where there has been a prenuptial agreement previously and has a greater understanding of such an agreement, then the court will take that into consideration as well. If both parties are mature and have a wealth of life experience and knowledgeable in relation to financial matters, then this will enhance the weight to be attributed to the terms of an agreement by a court. Conversely, if parties are young, immature and don't have a wealth of life and financial experience, then this may go against the terms of the prenuptial agreement being decisive. Do the parties need a full understanding of the implications of the agreement? Well, absolutely. Both parties need a clear and full understanding of all of the relevant information, financial and otherwise, to enable them to make a proper decision as to the terms of the prenuptial agreement. Before signing the agreement, both parties must have a clear understanding of the terms and implications of such an agreement. Ideally, both parties should receive specialist and independent family law advice. Both parties should each provide financial disclosure to the other so that that can be referenced in the prenuptial agreement. Only once both parties have a full picture of the other party's financial situation, then only then can they have a context in which to negotiate the terms of the prenuptial agreement. Such an agreement should clearly set out the financial consequences of any future breakdown of the relationship or of the marriage, and will set out how assets and liabilities are to be distributed or dealt with in the event of separation. Currently, although this is likely to change as the law develops over the coming months, Whilst prenuptial agreements are not entirely binding upon both parties, parties who enter into such an agreement should expect to be held to its terms. One of the questions we're often asked is whether the agreement has to be fair so that both parties are held to the terms of the agreement. Absolutely, it's unfair to prejudice the reasonable requirements of the parties, or especially any future child or children of the family. It's often a good idea to build into the provisions of the agreement what might be reasonable financial provision for the children in the event that children are born into the relationship. Such agreements must not prejudice the reasonable requirements of any children of the family. If therefore the parties have children in the future, it would be advisable that they reconsider the terms of the prenuptial agreement to make sure that there is reasonable and adequate provision for the children of the family. Often one of the driving forces in such agreements is where one party seeks to ring-fence assets which he or she will bring into the marriage so that they are not susceptible to attack in the event of a future divorce. There's nothing inherently unfair about prenuptial agreements seeking to ring-fence what is often referred to as non-matrimonial property. The longer a marriage lasts after a prenuptial agreement is signed off, the greater chance it may not be fair to hold the parties to it many years down the line in the event of a breakdown of the relationship or due to unforeseen circumstances. This is especially relevant to young parties starting off married life with few assets, and less relevant where significant assets have already been accrued before the marriage. If the terms of the prenuptial agreement are to ensure one party is left much better off than the other as a result of the breakdown of the marriage, then the court again is unlikely to uphold the terms of the prenuptial agreement because it would be unfair to do so. So as the law stands at the moment, prenuptial agreements which have been properly entered into, as I've referred to a moment ago, are likely to be as good as binding provided they are fundamentally fair to both parties. Currently, even if such an agreement is fair and has been properly entered into, the court still retains residual discretion as to how matrimonial assets and debts should be ultimately dealt with. The courts will take into account the terms of the prenuptial agreement, and as long as it's fair and properly entered into, the court is likely to hold the parties to the terms of that agreement. So what does the future hold in terms of prenuptial agreements? Changes in the law are being considered to make nuptial agreements that are in a prescribed form and adhere to certain safeguards to make them legally binding. A nuptial agreement which meets such criteria is likely to be termed a qualifying nuptial agreement. Qualifying nuptial agreements would prevent the court from making financial orders on divorce that are inconsistent with the terms of such a qualifying nuptial agreement, unless a specific financial remedy order had to be made to meet one of the parties' financial needs or for the benefit of a child of the family. So what are the criteria of these so-called qualifying nuptial agreements? Firstly, they must be contractually valid. Secondly, there must be no factors present that could cast doubt on the free will of the parties to enter into the agreement, or on the level of information or disclosure that each party had when entering into the contract. Any evidence of mistake, misrepresentation, duress or undue influence would undoubtedly cause the agreement to fail. Thirdly, a qualifying nuptial agreement must be validly executed as a deed. It must contain a clear statement signed off by both parties that they confirm that they understand the terms of the agreement and confirm that it's a qualifying nuptial agreement which will remove the court's discretion to make financial orders on divorce except to meet financial needs. Fourthly, a qualifying nuptial agreement must not have been entered into by the parties less than 28 days prior to the wedding date. Fifthly, both parties to the agreement must have received disclosure of material information, including financial disclosure about the other party's financial situation. Next, both parties must have received legal advice at the time they entered into the agreement. Importantly, a qualifying nuptial agreement must not prejudice any children. If the agreement makes insufficient financial provision for children, then it will be set aside by the courts. Finally, the needs of both parties must be met. Need is measured with reference to standard of living during the marriage, and an agreement that results in a party receiving nothing or very little will not be upheld by the courts. Clients often come and speak to us to obtain independent and expert family advice in relation to both the drafting and considering of draft nuptial agreements. The principles I've just been talking about also apply in relation to post-nuptial agreements. If you have plans to marry and want to give some consideration to entering into a nuptial agreement, please contact us, or you can find details of this and other family services that we offer at our website luptonfawcett.law.